you need to do that right off. You know, these arguments are live streamed, and that means what you say immediately goes out into the internet, and wherever the internet leads, it goes, okay? So I always try and urge people to think a little bit before they say something, and I think that's especially true when it goes out on the internet. So please remember that. If there are no announcements or anything, no. Well, would you call the first case, please?
Harold C. Bowden IV versus Amber Crutcher.
I'd like to reserve about 4 minutes of my time for rebuttal, if I could, please.
4 minutes, okay?
Good afternoon. My name is Kimberly Reed Bracey Johnson from the law firm of Freeman and Bracey in Davidson County, here for Mr. Harold Bowden, your appellant. This is a case that really follows along with my pronunciation will be horrible, Regendron case. And this was a case where in the trial court below, Sumner County, who was also the trial judge for the Regendron case, again ruled a 50-50 parenting plan for the parties in this case, and we would submit inappropriately so. And thus, we're here today to ask the court to reverse that decision. First of all, this relationship is not conducive for co-parenting and is contrary to the law that this court has put down. The mother, during the course of this litigation, moved 1.5 hours away from the father's residence. The mother's inappropriate behaviors prohibit co-parenting. We'll talk about the court's specific findings of her inappropriate behaviors. And the mother does not follow the orders of the court, to the point that, like Regendron, the mother filed a motion immediately after the trial was concluded because she didn't like the father's daycare decision. The father was successful. And we have submitted to the court a motion for consideration of evidence which could not have been known at the time of trial for the mother taking the child inappropriately to a non-emergent medical appointment without notifying the father, the sole decision maker of non-emergency medical, and telling the medical facility, please don't register that this appointment took place. They did. Anyway, there's 53 pages of those facts that the court had a lot to work with in order to make the decision, and I'm going to try to condense those into my next 9 minutes. Also including in the decision will be our request to have the mother's gross income for child support purposes conform to the evidence to $3,744 a month, and to look at the court's ruling on holidays, specifically, if I might, that the court gave the mother all of July 4th every year in exchange for the father receiving Juneteenth. It's worthy to note that my client is a biracial gentleman, and while we are certainly excited that he got Juneteenth, he's also a Black American, and so he would like his 4th of July back in alternating years. We believe this case is...
So you want them to flip back and forth? Is that
on
what?
the July 4th, okay. Correct. We believe this is a case of clear abuse of discretion with an illogical result just based upon the overwhelming facts that were presented. As we know, based upon the laws and case precedents that this court has upheld, that these types of custody arrangements of 50-50 are only appropriate in very limited circumstances and, quite frankly, are generally disfavored. This court has found that they require a harmonious and cooperative relationship between both parents. We don't have that here. The cooperation of the parties is a factor that we should consider today. This case screams Regendron, not only for the very procedural elements, where in fact it had a daycare motion after it, just like Regendron, where the mother was not going to follow and not comply by, not accept the ruling of the court for my client to have sole decision making. But the court in this case specifically found that there's just no relationship between these parties at all. In fact,
Counselor, question, in setting the dates at this point here, we have a child who's still in daycare, if I recall correctly. How much is the court supposed to, if at all, look ahead to school age issues? And here, my understanding is the move occurred before trial in this case, and that there's some complexity in terms of an equal time split with two parties that are an hour and a half now approximately apart. Is the trial judge supposed to make the determination for now based upon the daycare being more plausible in terms of, I'm not saying, and you have other arguments in terms of why you don't think that's the right allocation, but how much is the trial judge supposed to be looking ahead, if at all, to the school age years?
well, in this particular case, I think they have to look ahead tremendously because of the distance, and the daycare was ordered to be between the two of them. So now we have a situation where we're putting these two parties back in the position of having to go back, I think, this coming summer to litigate potentially a whole new parenting plan because of there not being the allocation of one parent being more time than the other. So we're left in a, I guess we'd say, a litigious nightmare, so that while we haven't gotten through the appellate process yet, even if we had not appealed, we're turning around going right back into litigation before the fall because this child starts to school in this coming August for pre-K. So it leaves people in a position of knowing that that is coming, as opposed to making a settled ruling based on clearly 53 pages of facts that don't just magically disappear. This child was, I think, 2.5, 3 by the time we got to trials, 3.5 now. So we're not talking about a small vacuum of a newborn. As this particular trial court said, there was a lot of time that had passed, and there was never a time when these parties got along. So to leave that kind of decision unsettled makes these individuals live litigiously until we return, unless the court, of course, adopts what we are proposing and takes care of that today for all of the reasons that we're going to present. So the court found there's no relationship between the two and that they don't get along. But the court did try to distinguish this from Regendron by saying that I'm going to try to solve this problem by giving the father sole decision-making on everything. But that doesn't solve a 50-50 arrangement where the people have to co-parent every day and where one is moved an hour and a half. It didn't solve any of the problems that Regendron had clearly said this is not an appropriate case for 50-50 parenting. This case is full of false criminal accusations by the mother against the father, threats by him, clear findings of inappropriate behaviors by the mother. The court said she exaggerated, she manipulated, she was fraudulent in getting food stamps, for goodness sake. So there were a lot of things that the mother was doing, and in many of these cases, she would call the police. If the father didn't cooperate or do what the mother wanted, she called the police. She told daycare, she told medical facilities, she told hospitals that she was scared of him, that he was a threat to her. But then she admitted under oath that he had never once threatened her in his life. So who could blame him for not wanting to co-parent with this woman? The only thing under factor 2 that the trial court found in favor of the mother on that one factor was that he refused to tell her where, not refused, she never asked, but he did not tell her where he had placed the child in daycare during his parenting time. But the mother admitted that she told one daycare facility, fortunately her own, that she was scared of the father. And she admitted that she had done that, and she admitted she lost the daycare because of that. So who can blame the father? Because she had turned him in at every turn erroneously. In fact, the police officer's video camera that was submitted into proof had the mother actually threatening him. And she admitted that she told the police officer that, hey, if the child wasn't here, I would have run over him with my car. This is not a situation where people can share 50-50 time. Conversely, the court found my client to be more responsible, more capable, had a steady job, had made wise decisions to give him sole decision-making. But what is he supposed to do? Just continue to put up with the behaviors that he has been the victim of? In fact, he even said publicly, she accuses me, but privately, she woos me. And this is true. She would try to get him to come to see her without even her new husband knowing it. He would refuse. He's scared of her. As a biracial gentleman and dating, or they were not even dating, had a relationship with and a childbirth with a white woman, he did not want to be put in a position where he could potentially face some type of false criminal accusation, and she tried repeatedly. So there's good reason to prevent these false allegations and repeated history of her unjustly calling the police. There were orders after orders and motions after motions, and none of them were deemed unfounded. My client was quite successful on every one of them, just about. Repeatedly, he even had to file this case to be able to see the child at birth. The mother slept with the infant in the bed with her boyfriend, now husband, had to get that stopped as unsafe. Refused to turn over the child at exchanges, had to have motions on that. Threatened the father with police intervention, even though the mother admitted the father had never touched her or threatened her. She constantly would say that she was afraid of him, even though there was no reason for her to say it. And just like Rajendran, the parties live an hour and a half apart from one another. But despite of all of that, the court ruled a 50-50. The Department of Children's Services was involved with the mother 3 times. The mother admitted that on the last DCS interview that they had with the mother in her home, their minor child, the minor child of this litigation, was present, and she didn't believe the father had a need to know. She had her new husband call this minor child daddy. She told a lie and said that he was infertile and that she wanted her new husband to adopt this child, but that wasn't the case at all. It was finally learned that the new husband was not fertile, and he had even given up his own child for adoption. She's left the minor child in the care of known drug traffickers, such that there's a restraining order in place regarding the parenting plan.
You know, your time is up.
I think, may I go one more minute and I'll do a 3? Is that permissible? I'll stop.
Yeah, just stop.
Okay, I will. Thank you.
We've already programmed the thing in.
No problem. Thank you.
May it please the court, may I reserve some time potentially, or I'm not allowed to do that?
You don't get to do that.
I've tried. All right.
Good try.
May it please the court, Amanda Thornton here for the mother in this case, Amber Crutcher. Your Honors, I will start with discussing the Rajendran case and compare to this, since that's kind of where the argument started. I think the difference in that case and what we have at hand is that these particular parties actually exercised a 50-50 from October of 2021 until we tried this case. And so they have shown that it worked, because the testimony from both mother and father at trial was that this child was happy, healthy, great, everything worked. And the trial court in their ruling even noted that multiple times, that they've been doing this schedule. And I will say that while I don't disagree that the parties are not necessarily completely harmonious given the record, that it swings both ways. Looking at the record and when certain allegations of incidents occurred, the majority of it was in the beginning of this child's life. Father actually filed his petition prior to the birth of this child. So he filed this while mother was pregnant to begin this. And then a lot of these alleged incidents occurred early on. You will note through the record and through the testimony of the parties that as time went on, mother then tried to involve father and tried to co-parent. As a matter of fact, the trial court says the problem in this case is we have father who doesn't want to have anything to do with mother, doesn't want to communicate with her, and we have a mother who wants to completely incorporate father and do a blended family, because that's what she had been used to. And the question, I think, is what's worse, to have a parent that wants nothing to do with the other parent, and if he could, would completely remove her from the child's life. His own testimony was that he had gone on several trips left the child with other people and never told mother, but then when he was questioned, would you want that same respect? Yes, I want to know where he is. Yes, I want to know where he's left.
Counsel, I'd like to ask you the same question I asked opposing counsel, roughly the same question. Here we have a child who's approaching school years of age. Is the trial judge supposed to think about that in entering this plan? How important of a consideration? And you're saying the 50-50 worked, but we now have two parties that my understanding is shortly before the trial, we have a move. They're now an hour and a half apart. You have a child who's starting school. Should the trial judge be thinking about that in formulating the parenting plan? What's the role of that consideration?
I understand. And for the record, I would say that mother actually moved way before the trial.
Okay.
So they had done this parenting plan. She had actually moved early on to Clarksville and had lived there for some time. This 50-50 schedule had worked for since October of 2021 with her in Clarksville. So that, obviously proven to work. However, I think the question is, we've got a parenting plan that's always within the discretion of the court if issues are raised or material changes to modify, right? We don't get a parenting plan that's an end-all be-all in every case. And so because of that, I think it's probably often difficult for a court to say, hey, this works now, but I'm going to go ahead and say it's not going to work in a year, or it's not going to work in 5 years, or it will work in 10 years. And so, for a trial court, what they're faced is, what do we have now, and what has worked, and how is this child's best interest being served? And to circle back, that's kind of what the trial court said. Look, y'all don't get along necessarily. You don't co-parent well. So I am going to decipher this from regendering, and I'm going to give dad some higher decision-making, right? But as far as a parenting schedule, it worked, and it worked at the time. Now, what happens in a year, 2 years, 5 years, or 10 years, I don't know that the trial court can necessarily prejudge that and say, we've got a schedule that's been working, that's going to continue indefinitely until we reach that hurdle, because that's what is allowed by the court, right? A petition to modify when there's a material change. And so based on what the court had in front of them, it was in the child's best, or is in the child's best interest, to continue a 50-50 plan, because by all accounts from both of these parties, this child was doing well. And I do think the trial court tried to alleviate some of the concerns from the co-parenting issues and give dad decision-making. One thing I want to note is that throughout the record, it's inundated with allegations against mother, but the court will see that often it was the same. Father would point fingers. We heard about mother having her husband called daddy, but there was proof in the record testimony that father had his fiance made mommy shirts for the child. There's no difference. We had in the record where fingers were pointed at mom because she has 2 other children by 2 other men, and had been married before twice. But yet we didn't point fingers that dad has 3 children or 4 children by 3 or 4 different mothers. So the problem is, we come into this going, she's this horrible person, but yet dad's kind of on the same level. But ultimately, this child was doing great. This child, by all accounts. And in regendering, the court talks about how it's not necessarily a balancing or tipping of the factors, right? And the trial court evaluates the factors, and it's not a dad has 7, so he wins. That it's the trial court that puts the weight behind each of those factors. It's not more factors weighed heavily in favor of you, so you get you get primary parent and more time. So in this case, the court did just that. Although some factors favored dad, some factors favored mom, and some favored both parties equally, the trial court saw these people for 2 years. The trial court didn't abuse its discretion. The trial court was familiar with these parties, their personalities, the dynamic. The court even said, the problem is this relationship was built, there was no relationship. This was a pretty quick situation between mom and dad early on. If I can, I would like to talk about the child care expenses as well. I think that was an issue that was filed after the order went down, but that's because the initial order had a 50-50, a split of that, because mother had proposed it. Dad chose another daycare that was a lot more expensive. There's no denying the fact that dad has a higher earning capacity and earns a greater income. We don't deny that. So as a result, that issue was addressed when the cost of daycare was a lot more than what mom had thought it was going to be when she offered a 50-50. The court then applied that and did it on a pro rata basis, which is what the guidelines provide for, and say they shall be included, the Tennessee Child Support Guidelines. And as far as mother's income, Your Honors, I would say that the court again reviewed pay stubs, tax returns, and the court determined mother's income. She did not come in voluntarily underemployed. There was a reliable source of income for mother, showing what she actually had the ability to make. And so, Your Honor, what we would say is that the court did not abuse its discretion. This case, although some of the factors may be similar to the Regenderen case, and I understand it came out of the same court, that the court did take some precaution, and the difference is we had two parents exercising an equal schedule, living an hour and a half away from each other from early on in this case, not right before trial. This was not a mom had been living there a month and we're going to try it and see if it works. This was there's a proving record here that this child has done well by the parent's own testimony. And so it works, and it was in the child's best interest, and that's why the court chose to pursue that and leave that in place, because changing that would not be in the child's best interest. Decision-making, you know, I think that was a safeguard by the trial court as well because of the lack of the parents' ability to necessarily agree on everything, and so that's been put in place. And so we would ask that the trial court's decision be upheld, and that the courts find that the trial judge did not err in the decision made.
No
Thank you.
questions.
Quickly addressing, before I return to my other points, some of the arguments made by my worthy adversary, we would submit this did not work. It had not worked all along. In fact, in between the two trial dates, my client called the Department of Children's Services because the child showed up with a black eye and a safety plan was signed by the parties. My client testified in court that he showed up with a black eye, that the child would return to him with bumps and bites, smelly feet, smelly shoes, swollen eyes, hand-me-down clothes far too big, and quite frankly, dirty. So those types of communications and evidentiary testimony doesn't sound like that the parties were working well the entire time, but my client didn't have a choice in the matter. He had to follow the court's order until we got to trial and hopefully could change it, and now that's why we're here at the Court of Appeals. So it not only didn't work, it's been unsafe. As to education, I wanted to point out that the mother's other two children are not attending school in Montgomery County where the mother lives. They're attending school in Cheatham County where the mother's mother lives, and that is what they've grown accustomed. So for education in this case, we could make some earlier determinations based upon the facts presented in court, because the mother has not been doing the primary educating of the other two children. They're going to a different county, a school where her mother, I think, works or teaches. I can't remember which.
Is that in the record?
It is, Your Honor.
Okay.
Yeah, but what's the basis for imputation here? I mean, I'm struggling to see what the trial judge got wrong here in terms of income.
I'm not asking it to be imputed. I'm asking it to take her testimony based upon her number of hours and her hourly rate at two different jobs and how she worked in that schedule. And if you add those up, that's the number we come to. It's not even imputation. I do believe she could make more than that with what she does if she were to work more. But we just took the facts and evidence. And
So just a pure miscalculation, though.
Pardon?
Just a pure miscalculation.
That is our understanding, based upon the evidence she presented. And as it relates to her, even if imputed, but it's not, but even if it were, I think it could be higher. The mother had 10 different jobs in the time that my client has known her, and she quit almost all of them. So imputation wouldn't be a stretch. But we didn't do that. We took the actual hours and the numbers of the two jobs she said she worked. And that's what we went with. So we believe that it is a case that needs to be overturned, and the father deemed the primary parent not only for sole decision-making, which the court got right, but also for the time involved. Regenderen talks about best interest, and it's not favored to do 50-50. But giving someone sole decision-making doesn't cure that problem, a problem that's paramount and continues to be a problem based upon my motion even after the brief was filed to consider facts not in evidence. She continues to do the same types of behaviors.
Suppose we agree with you that 50-50 isn't appropriate. Do we set it, or do we send it back to the trial judge?
We submitted our Exhibit 13 in the record, which is the father's proposal. We know that you have the authority to do either one of those, but we do believe whichever one the court chooses to do, whether it's adopt the father's plan with the amendments of testimony on holidays and things like that, or whether the court remands it. When we saw Regender, I don't know that it ever came back. I think it might have been agreed to. I don't know what happened in that case. But we believe either direction, the trial court below would follow your directives, and certainly my client would follow whatever the order is. Thank you.
Thank you. Thank you both. Would you call the next case, please?